are hearing from former President Donald Trump on his social media platform, Truth Social, saying that he is canceling this scheduled press conference that was going to take place in Bedminster, New Jersey on Monday in relation to what happened this Monday, those multiple indictments against 19 defendants, of which Trump is one of them, stemming from the 2020 election. We were told, according to the former president, that he was going to be releasing massive evidence of widespread fraud that happened in the state of Georgia during the 2020 election, but that is now no longer happening. I want to put up the post here. We made this graphic here. This is what the former president says. Says, rather than releasing the report on the rigged and stolen Georgia 2020 presidential election on Monday, my lawyers would prefer putting this, I believe, irrefutable and overwhelming evidence of election fraud and irregularities in formal legal filings as we fight to dismiss this disgraceful indictment by a publicity and campaign finance-seeking DA who sadly presides over a record-breaking murder and violent crime area, Atlanta. Therefore, the news conference is no longer necessary. So we want to bring in former federal prosecutor and friend of the program, Doug Burns, to the conversation here. Doug, good to see you. You know, when we were talking today, I was going to ask you whether or not this is a good idea if Trump should still have this regarding all the legal trouble he is in, especially there in Fulton County. And then literally 10 minutes ago, we got this post on Truth Social. After this ABC News report earlier this morning saying that his lawyers were strongly advising against it. This is a good move, right?
Yeah, it's a good move not to do the conference for sure. I don't believe in blanket rules, and there are exceptions to every rule. But the general rule is that if you're under indictment, regardless of the political discussions, you know, we can put that to the side. If you're under indictment in a criminal case, it's probably better advised not to do that kind of conference. It's very interesting, though, because I think there will be a little political blowback on the former president, you know, who said with great grandiosity that, you know, he's going to release a report that's going to show all kinds of definitive fraud. And then he had to sort of backpedal off of that. So that's interesting. And then he put a big spin on it, you know, worthy of Wimbledon. You know, we're going to come forth with the report. However, we're going to do it in legal filings, which implicates a secondary point, which is, you know, if these filings are available to the public, then we're going to see if he puts it in there or not.
But also, if he is going to put them in legal filings, they have to be true and accurate. You can't put misleading documents on the docket, right?
Well,
if there's no evidence of fraud, which we know there's not.
Yeah, but you're asking an amazing question. So let me just break it down because it implicates a few little in the weeds spin points. When people file affidavits, that's a sworn statement under penalty of perjury. Affidavits often accompany legal filings. If you put a falsehood in there that is demonstrably false and can be proven to be false, that's real serious. When lawyers file briefs, however, you know, very often they will put heavy characterizations on things, and it's not under oath. So it starts getting a little bit tricky. Now, you know, most ethical lawyers are obviously not going to be putting, you know, false material that they know to be false in a legal filing. But at the same time, there is a big technical distinction between a sworn affidavit and a simple legal memorandum or brief. So again, we'll have to see how this all plays out. But that's very typical of Donald Trump. It's kind of the way he operates, which is to say, you know, I'm going to blow you out of the water. I mean, that's his whole scorched earth sort of approach to things.
Yeah. And we do know as well that we were hearing from his attorneys in all of these cases, especially though the 2020 election interference cases, that they intend to essentially, you know, relitigate the 2020 election in court. They want to bring up everything that was discussed. They want to talk about all the, you know, perceived or alleged fraud, at least from their side, that they think occurred. And they want to duke it out, hash it out in court once these trials take place. I thought it was really, really interesting, though, in the Truth Social post, because you and I have talked so much about the former president's state of mind and whether or not Fani Willis, whether or not Jack Smith can prove that he, in fact, knew that he lost the 2020 election. And I thought what was really interesting in the wording of that, and if we can put the Truth Social post back up, that he essentially said that I believe happened. He made that caveat in the Truth Social post.
Of course. Mens rea or intent is critical. It's going to be very, very difficult to prove beyond a reasonable doubt in a criminal courtroom that he knew that he lost the election. And as I told you previously, one thing we love is the fact that you can't argue both sides of the room, ladies and gentlemen. I'm launching into a hypothetical summation. On the one hand, folks, they tell you that he walked around like a lunatic, insisting over and over and over that he won. And then they just breathlessly pivot like on a dime, ladies and gentlemen, and say he knew he lost. I think that's going to be difficult. Now, the other thing that's interesting is that a courtroom is much different than the public square and the media. So there may be, possibly, I'm not saying this is the case, but there may be a little bit of bad news for the prosecutors in what you just teed up. And that is that, a lot of the claims, any claims of fraud were, just met with hysterical, cancel culture and all of that. But if he gets an opportunity in a courtroom to demonstrate some of it, I'm not saying he'll be able to, I don't know. But if he does, hypothetically, then it might be interesting, actually.
Yeah, Doug, I want to just move on from this. That was just some breaking news when we brought you on. And I want to get to the Georgia indictments that were handed up on Monday night. And
Sure.
We learned a lot about what Fani Willis and her prosecutorial team intend to do with them and the timeline, at least a perceived timeline. She wants the start of the trial date to be March 4th of next year. And we're also being told, Doug, unlike the previous 3 indictments where the former president went to the courthouse to be arraigned, there in Fulton County, he'll have to go to the jail to be booked, fingerprinted, and mugshotted before August the 25th, next Friday. So there are some differences here. But you and I were talking earlier this week that if a prosecutor wants a trial date, that's all well and good, but that's aspirational. It's up to a judge to set that, right?
In 38 years, real simple, in a case with 10 or more defendants, I'll use 10, not 19, I've never seen a case even remotely even be considered to go to trial in that time period. Okay. I'm not editorializing, by the way. I'm just telling you the realities. There is no way, 0 out of 100, that the case goes to trial in March. You can just amplify my point by the fact that you have 2 federal indictments pending that were filed before her case. So again, I'm not knocking the prosecutor in Georgia. I'm just telling you that these are political, statements and stunts, and it's a little bit disconcerting for somebody like me who's been in hundreds and hundreds of real-world cases for 38 years. It's not going to trial in March. Never going to happen. You have 19 defendants. First of all, you've heard people refer, and it's worth repeating, the president and Mark Meadows, those 2 for sure, possibly a couple of others, but let's just concentrate on them. They have a petition to remove the case into federal court. If you look at the statutes, which is 28 USC 1442 and 3 and 4, et cetera, those statutes say that if somebody was serving as a federal officer during the time period alleged in either the civil complaint or the criminal indictment, they can file a petition in federal court to have the case removed, switched to federal court. If that were to happen and Trump and Meadows prevailed, that would create a fascinating dynamic, because then the prosecutor in Georgia, is sort of removed from play, and it would be in federal court. So that's going to be step one, is the removal petition. And the other point in the weeds, but important for the viewers, if Trump were to lose that and the federal judge said, no, the case should remain in state court, he might be able to appeal that in what we call an interlocutory appeal, an immediate appeal. And that's also going to take time. And then lastly, it takes a lot of time with 19 people. Yeah. You go to status conferences. So it's just not going to trial in March, in my opinion.
Okay. What you're speaking of, and we're talking all about this, trial timeline, when 2024 hits, at least some of these dates that have been proposed is going to be so busy and hectic for the former president, even while he's trying to be a candidate for president in 2024. I think this is a really good kind of graphic here, this tweet that was posted by John Hassan of where the political primaries are, the dates of them, where the dates as well in the middle of the trials that have been somewhat set, or at least the prosecutors have put these dates forth. So you have January 2nd. That's when Jack Smith and his team want the trial for the January 6th case in federal court in D.C. We just heard from Trump's attorneys that they want that pushed back to 2026, Doug. Because
I heard that.
Yeah, because they need time to prepare their defense. So, and then you go into March of next year, Doug. That's when Fani Willis wants the trial for the Georgia case, the 4th. The next day, Super Tuesday. So many states' primaries happen that day. And then you go later in March, the 25th, the Trump trial in the Alvin Bragg case there in Manhattan. And then you go to May, that's when Jack Smith wants the documents case there in Fort Pierce, Florida. So, it's almost overwhelming just to think about all of these legal schedules the former president and his team of attorneys will have to comply with. But these are just the main ones. There are several others as well, too, civil ones in New York and elsewhere. So it's shaping up to be quite a hectic 2024 for the former president. Do you think any of these dates are going to stay like this?
Well, it's interesting because judges do have the ultimate authority, and I've been there many, many times, albeit in, lesser high profile, where the judge just says, look, the trial is going to be next Friday. We're going to start with jury selection. And then, but Your Honor, you don't denied. I'm sorry. The judge has the ultimate authority. So I can't predict with a crystal ball what these judges are going to do. But you make such a great point, which is, oh, my God, we're using the word unprecedented a lot. But, I mean, how could you have 4 trials going on with a presidential election campaign season? That's impossible.
5 months. Within 5 months of each other. I mean, that's what I think is it's just so hard for me to wrap my head around. Like, how can this even be feasible? How can this even happen from just a logistical standpoint?
Well, I mean, look, I'll give you a political editorial, obviously, which is not what you had me on for. You want to talk law. But I mean, obviously, look, there is an agenda to want to get these cases to trial before the election. Let's not sugarcoat that. Okay. It is what it is. The government never asks. I told you this, and actually got in a minor dust-up with our distinguished colleague, Randy Zellin, who's a great lawyer. But I told you guys with some minor anger that the government simply never asks for a speedy trial, okay? They don't care. Okay, not that it's not important, but speedy trial is a defendant's right. So, Your Honor, my client has the right for a quicker trial. I'm the defense lawyer, and we would like this case tried in March. But you never hear the government say that, not because they're, lazy or doing anything wrong. It's just it's not their right, and it doesn't really matter. So here it is crystal clear that there are political factors involved in wanting to get these cases to go to trial on timetables that are ridiculously unrealistic, which, kudos to you, is your exact point. As a journalist, you see how unrealistic it would be to have 4 trials. Again, I'm chuckling, but 4 trials during a 1-year presidential campaign season?
Yeah. I mean, it's so interesting. I want to just kind of cite some of the comments as well made by former Attorney General Bill Barr. He was on with Fox's Neil Cavuto today. He was talking and asked about the Georgia case. He says this, Doug, well, I'm not happy with the Georgia case. I think it's much too sweeping, much too broad. It's excessive case that is, make it look like people are piling on and being excessive to Trump, and you feed the narrative that he's being victimized here. That's kind of what you have been alluding to, telling me on our stream here. You kind of agree with Bill Barr.
Well, all I can tell your viewers is that I've never seen anybody murder, racketeering, drug dealing, organized crime. I've never seen anybody indicted 4 times at the same time. So that should mean something to somebody watching. Yeah. Okay, I've been in hundreds and hundreds of federal cases. I've never seen anybody indicted 4 times. So the first question is, and again, I'm not defending Donald Trump. That's not my point. It's just legal X's and O's. My question is, why did they therefore indict this man 4 times? when none of it is anything other than what we would call white collar type offenses.
I see.
So Bill Barr is an interesting character because, he had some serious dust ups with the president.
Sure.
And he came out against him on a few things. But I mean, I would think it's a dereliction of your basic legal integrity to say anything other than that this is piling on. The use of RICO is excessive, and 4 indictments is over the ski tips. But at the same time, being fair, you're entitled to think that the president's conduct was terrible. You're entitled to think that one prosecutor could have brought one case against him. And historically, we would have had the president of the United States under indictment. That's all you need. I'm not arguing vigorously against that. The indictment could be 10 pages. It could be 3 or 4 counts. But when we segue to 98 pages, the definition of an indictment that's too long is that when I printed it, I now need a new toner cartridge, okay? So you have a 98-page indictment, multiple counts. You're calling lawyers racketeers, okay? And it's just over the ski tips. So again, to repeat, you want to indict Donald Trump? Fine. Pick your strongest case, return a 10-page indictment, 3 or 4 counts, and then we'll bring it to trial, even possibly before the election. Here's where they kind of shot themselves in the foot, so to speak. They bring 4 indictments, and how ironic is it if none of them go to trial, when if they followed my formulation, my hypothetical just now, of bringing one 10-page indictment with 3 or 4 counts, so you bring it to trial in the spring.
Yeah. Just lastly, Doug, while I have you, we got some news today, and this was a statement put out, this news release by the Fulton County Sheriff's Office, saying that the office is aware that personal information of members of the Fulton County grand jury is being shared on various platforms. As the lead agency, our investigators are working closely with local, state, and federal law enforcement agencies to track down the origin of threats in Fulton County and other jurisdictions. Fox's Jonathan Seri tweeted this screen grab of the statement. It goes on to say, we take this matter very seriously and are coordinating with our law enforcement partners to respond quickly to any credible threat and to ensure the safety of those individuals who carried out their civic duty. Threats against the grand jurors in Fulton County. This dovetails with the news that we got yesterday. A 43-year-old woman, I believe, in Texas was taken into custody over threats she made against Judge Chukin in D.C., who was presiding over the January 6th case brought by Jack Smith. Obviously, no one condones violence. Threats are just horrible to be made against these people, like the Fulton County authorities said, doing their civic duty. But I'm curious, Doug, does this matter? Does this factor into how these trials will move forward? Will, say, the prosecution in either of these cases, go with this essentially to a judge and say, look, threats are being made?
Well, it depends whether the threats are being made by individual citizens who have strong feelings about the case or somebody tied to the case itself. And again, in our climate, generally, people tend to, rush to judgments and conclusions. It should be looked into very carefully, obviously. The first determination is what I just laid out. Does this have anything to do with anybody associated with the case? Or is it just some citizen acting in a criminal fashion, making threats, and then figure it out? But to your question, I'm not ignoring it. It's just another thing which could ostensibly take a bit of time. I don't think it would be very long. Conduct some kind of hearing, maybe behind closed doors, call the grand juror in, find out exactly what the threat was, then have law enforcement take a look at it, look at some phone records and things of that nature, and go from there. But again, I don't think it has a big impact on the scheduling of the case, if that's what you're asking.
Okay. As always, Doug Burns, we really appreciate your insight into all of this. I have so many questions all the time for you, and we'll definitely be speaking again.
Appreciate that. Thank you.